So welcome back to this session. So in this session, what I did that we will read through these sections, but I felt that if I make some presentations, you will have more better understanding and write some few points so that it is more easier for you to read those points and refer to those points. But here one request is that because this I have wordings I have changed. मैंने इसका wordings change कर दिया है. So I have changed the wordings. So what will happen that the exact wording is not there. So you should not get confused by that wording. So I've simplified the wording. So for me, it is easier to understand and easier to interpret. But in case of any doubts or for full clarity, I would request that please read the pattern egg as given original. Okay. Don't, what I mean to say that don't rely on these PowerPoint presentations. Okay, this PowerPoint presentation will help you to quickly understand the things as it is and memorize them and clearly clarify, because I worked very hard to make this. I spent almost 16 hours for this to prepare these slides, and still it is under process. I have to make more slides for you, and I have taken all the rules, all the forms, all the fields on one slide for each sections. So it is easier for you to refer as and when required to these recorded sessions. So I start here with pre and post grant oppositions. Okay. So please remember this, and everything is written in very short language. Sometimes I have written in long sentences, but this is how I remember this, and I hope it will be helpful to you also. But don't rely on this. If there's any confusion, you don't understand my language or the way it is written, please refer to the actual acts. Okay, so here we start. So section 25(1) is pre-grant oppositions. Okay, so I'm not going to, you can read the sections of, you can please keep the book in front of you as we discuss, so that you can refer to this, but we will not read those line by line from now onwards, because what I felt that it is sometimes difficult for many. I got some feedback that when I read this, it is difficult for many to follow this, and they are not able to catch up. What I said, which form, which fees, which rule, they are very confusing, and you are not able to make the notes. Therefore, I have prepared these slides for you. Okay, so this is very simple now, and we can go very fast with this idea. So pre-grant oppositions, what does this pre-grant opposition means? Pre-grant opposition means that application is published, okay, is published but not yet granted. Okay, the application is published but not yet granted. Okay, so therefore you can when you see the abstract, you see the you understand something, and then also you can ask for the inspections. Okay, so there is a provisions that you can ask for the inspection. You can ask for the specification, you can ask for the drawings, as we saw in section which section? 11. Which is the section? 11A. 11A 6B. So according to section 11A 6B, we can ask for the inspection after the publication by paying some fees. Okay, 320 for inspection and 800 for the specification. You can ask, and then you can read, and then you feel that I need to oppose this pattern. So what you can do? Any person can do. So remember this: any person and person interested are different. So who is any person? According to section 2(1)(s). Okay, 2(1)(s) includes government also. So government can also do this. Okay, when to file? So patent application is published but not yet granted. So you can file pre-grant opposition under section 25(1). Patent application published but not yet granted. And how to oppose? Okay. So how you can oppose this? By writing the controller. And what it is called? It is called representation by way of opposition to the controller. Which form to use? The form is 7A that you need to use. And how much fee? There is no fee for this. Okay, you can do this. And for details, you read Rule 55. So Rule 55A says that patent is granted after 6 months from date of publication under section 11A. So after the application is published, patent is granted after 6 months only. So technically you have 6 month time before it is granted. So you can oppose. So there is it gives a window period for anyone to oppose. And Rule 55(2) what says? Controller will consider such representation only when the request for examination application has been filed. Okay. So what it means that if you see an abstract and you feel that we should oppose it, and why anyone going to oppose the patent? Because they feel, say for example, I am working on a cobalt catalyst and application has been filed for cobalt catalyst, but I have not filed any patent for this. Okay, but I have been using the cobalt catalyst. But in future, if this patent gets granted, then what will happen? Then what will happen?
Someone person are preparing for that. There will be some restriction for doing something in that cobalt.
Yeah, so I will be in problem, right? After getting the grant, then he will sue me saying that you are infringing patent. So therefore, what it may practice that I will ask the patent office to that I oppose this. So there are certain grounds on which you can oppose. We will discuss on what grounds. So when you file a pre-grant opposition, you need to give that I am filing pre-grant oppositions under these grounds. Okay, but controller will consider your pre-grant oppositions only when a request for examination has been filed. Sorry, so what it may happen that a person file an application, but he does not wants to proceed, and he has not filed request for examination. So if the application is not filed for examination, it is not going to get granted, and if it's not going to get granted, I have no problem. So there is no risk involved in that scenario. So there is no use of going for hearing and he has filed and this is not applicable. There are prior arts or there are prior use. So there is no use of undergoing such process. Therefore, controller will consider our pre-grant opposition only when the request for examination has been filed. Okay. Request examination can be filed according to section 11B within 48 months, and you need to fill form 18 and pay the fee of 4,000, or as the case may be for small entities or that industry. So you need to fill form 18 for filing examination. So if that is not filed, that means they can wait for 48 months. 48 months before controller considers your pre-grant opposition. Okay, and role applicant. Okay, so Rule 55(3) says in case of refusal or required amendment, controller will give notice to the applicant. Okay, and role applicant. What is the role applicant? When applicant receives notice as per Rule 55(3), applicant needs to give response within 3 months from the date of notice. So what happens that application is filed and it gets published according to 11A, and then it is not yet granted, and you file a pre-grant opposition by way of representation using form 7A. Then controller will give notice to the applicant that see your application has been opposed by way of pre-grant oppositions. Then when the notice is given within 3 months from date of notice, okay, within 3 months from date of notice, with a copy to opponent, he will give. And then what are the outcomes? It could be reject the representation, means after discussion, controller says that the claim means I want to oppose it, my representation is false, means it is not valid, or if required, he can complete a specimen can be amended before the grant. So if I say that this claim is it is not valid because there are prior arts, or I know this, there are some prior use, or other, or maybe there are different conditions we'll read now, and then those amendment will be there, or refuse to grant a patent application, or controller can refuse. So these are 3 outcomes. And time taken for final decisions, 1 month from date of completion of proceedings. Okay, so when controller will give the final decision, so if there is a hearing, means you file the application, and then there is a time period before the grant, pre-grant opposition has been filed by way of representation, and then discussion happens between you and the opponent and the controller. Controller gives his justification within 3 months. So he gets a time of 3 months to reply to the controller, and then everything happens, and then controller will take 1 month time from date of completion of proceedings before giving his judgment, rejection or requirement or refusal to grant. So he will take 1 month time to decide. Okay. And
question here, Prem, I have a question.
Yes, please.
In case of prior use, for example, if the prior, you told that we are using the catalyst in the laboratory, but it is a kind of a trade secret. We have not published anywhere that we are using this for this purpose in any conference or in symposium like that. In that case, how the opponent who is opposing the pre-grant, how we can furnish the details to the controller?
No, I did not understand, Basu, what you said.
For example, we are using a catalyst which is going to about to be applied for a patent grant, and we don't have the records in any public domain that it has been used by us. It's only in our record. It's only in our laboratory. In that case, how we can furnish those details to the controller for opposing that pre-grant opposition patent? Okay.
So, yeah, let me again repeat the questions. So the scenario he is talking about is, say a publication, there is a publication of applications, okay, application for the patent, and it talks about the cobalt catalyst. And I am from a company which uses the cobalt catalyst, or I'm a researcher, or anyone who are using the cobalt catalyst, but this catalyst is not in public domain. And now I feel that if this application get granted, then I will have problem. So I want to oppose that patent before it gets granted. But the challenge here is that the cobalt catalyst that I'm using is not in the public domain. It was just trade secret for many years where we are using it, and we are successful in the market. Now what to do this? So in that case, there are other provisions on the grounds on which we would like to oppose this. So there are some grounds of oppositions we'll discuss now. So you can try to hit your opponent based on other grounds. Okay. So this is the form, how it looks like. You can see that it says the Form A, Patent Act 1970, and Section C, Rule 55. So here it is mentioned, and you need to write the details. And pre-grant opposition. So what are the grounds of oppositions? Okay, pre-grant oppositions. So 25(1)(a). Okay, wrongful obtainment of patent. Okay, so if it is a case of wrongful obtainment of patent, means you need to prove that the patent that was filed, it was wrongfully obtained. Means he's not means without his consent, or actually you were doing and the lab notebook was stolen, or the idea was stolen, and he's not done anything experiment. So those things you need to prove. It was a wrongful obtainment of the patent. So that is one ground. Okay. And B, presence of prior arts. If you can, if it's not, you can also publish patent, okay, or the prior art should not be section 29A, matter published was obtained by applicant and published without his consent. Okay, an applicant made the application for the patent as soon as he came to know about the publication mentioned in section 29A. So the presence of prior art and the published patent and the prior art should not be what it says. If you read the section 29, okay, section 29, what it says that section 29 that we need to prove, okay, what we need to prove that the matter was published, okay, matter published, and as soon as one comes to know about this matter, you have filed the application. Clear? Matlab, there is a publication, okay, and suppose myself and my friend, we are working in the lab, and then the person working in the lab with me, I fear that yesterday he went to patent office and he might have filed the application, or we came to know about this, okay. Then we are shocked, how he could do without my consent and without my permission. Then immediately I also file a patent. So that need to be proved. That this is how I did. Okay, this is how I did, and then we can show that that this is a wrongful obtainment, and then I file a patent. Okay. Then secret patent. Secret patent according to section 13 1B, you know that published after or on after date of priority of patent application, but having earlier priority date. Means I filed a patent today, but someone has already filed a patent before me with a priority date of previous, but it has not been published. It got published only after my filing date. So I had no clue that this patent could exist, or this there is something that similar can exist. So I filed the patent. So those are called secret patent. So that also you can bring. Evidence of public use. Okay. Evidence of public use or publicly known. So this also includes product made or known process, or product made by the process is important in India. Okay. So D, the invention so by claim any claim of the complete specification was publicly known or publicly used in India before the prior date of the claim. So there is a prior date of claim, and you say the product was already publicly known, or another criteria is like, for example, the product was not known in India or not manufactured in India, but a product by the patented processor was made in, say, US or any other country, and it was imported in India. Okay, then also it will be known, it will be considered as if the product is known in India. Okay, so that also you can show. Okay, but there is an exemption. Public use is exempted for reasonable trial or experimental purpose only. But if that public trial was for the purpose of reasonable trial or experimental purpose, so those will not be counted for oppositions. Okay. Any doubt till now?
Prem, I just have one query.
Okay.
Like you mentioned, this pre-grant opposition, once it is published, so before grant anyone can oppose, right? So here the essential condition is request for examination has to be filed. That is what you mentioned, right?
Yes.
So if suppose if he has not filed a request for examination, in that case, can we oppose still, or it is not possible at all?
Come again.
Suppose if that applicant has not filed a request for examination, and still if somebody want to oppose it, so is it possible or it is not possible at all?
See,
if he has not filed the request for examination?
no, we are not concerned he has filed a request for examination or not. The once it is published, we can file the pre-grant oppositions by way of representation. Controller will consider our request only when the examination request is filed. Okay.
Okay.
I have one question here, in continuation with Satish, that how you is there any provision in the Indian Patent Office? Can you come to know whether it has been already request for the examination?
Yes, there is a provision. Okay, we'll discuss on that also. So there is a provision. You can ask for those details. It is filed or not.
Okay. Then after that also we can file it, right?
Yes. Okay. And there is a one nice provision. Now you will appreciate that request for examination. If you read the request for examination, what it says, no application for a patent shall be examined unless the applicant or any other interested person. Okay. So request for examination can be made by the applicant or any other interested person. Means, or which interested person? A person who has business, R&D, or substantial involvement in that invention area. He is called the person interested. So if you are that person interested, then you can also file the request for examination, and you just pay the fee, and the examination will proceed, and then your your opposition will come in force, and then you prove that these are grounds of oppositions. So this is what we're discussing now, grounds of oppositions, and then it get killed. Okay, clear? So 25(1) is obviousness. If you can prove that it is obvious or it lacks inventive step. So what is inventive step? I have written here according to section 2(1)(JA. You need to refer these sections 2(1)(JA). 25(E) is not an invention, or not an invention, not patentable. According to section 3. So if you can prove that it is not an invention and not patentable, or not patentable, so then also that will be get killed. Or if it's not that case, according to section 25(1)(G), insufficiency of complete specification. What it means that does not describe invention or method by which to perform it. If you can prove that the specification is insufficient, means whatever is given there, they have not described how the claim element to be performed and to be done. So then also that will be rejected. So according to section 10(4)(A), if you read section 10(4)(A), what it says, 10(4)(A), fully that every complete specification shall fully and particularly describe the invention and its operation or use and the method by which it is to perform. So 10(4)(A) says that complete specification should have these elements, but if these are missing, then it comes under insufficient complete specification. H, failure to comply with section 8. So what is H number? If you can prove what is H, so section 8 is information and undertaking for foreign application. So whenever you are making a foreign application, then that need to be informed. So if you come to know that this company has filed a patent outside India, and then you ask for the documents, as I told, there's a provisions, you can ask for the documents, and then you know that they have not given documents. Okay, so then what you can do, then you can say that, see, they have filed documents, you can prove the document that it was filed and there's no document in the history, and you can oppose this. So section 8 says, where an applicant for a patent under this act is prosecuting either alone or jointly with any other person or application for a patent in any country outside India in respect of same or substance same invention, or where to his knowledge such an application is being prosecuted by some person through whom he claims or by some person deriving title from him, he shall file along with his application or subsequently within the prescribed period as control may a statement setting out detailed particulars of such application. So what is the prescribed? Is 6 months. So within 6 months, you need to tell that you have filed these applications, and you need to give. And you also need to give an undertaking that up to the grant of the patent, you will keep in writing, inform the controller about these things. But you see that they have not complied with this section 8, then what happened? That will also be condition ground for the pre-grant opposition. Okay, convention application not filed within 12 months from the first application date. So if it is a convention application, if some person from other country who is from the convention countries has filed, but he filed in India after 12 months, and you can trace those dates. Okay, you can trace those dates and submit the proof that it is the case. Then that could also be the case. Wrongly mentioned geographical source. So section 10(4)(d)(2)(b). Okay, 10(4)(d)(2)(b). It says that you need to describe all available characteristics required to be correctly identified and indicated are included in the specification, including the name, address of the depository, institution, and date and number of deposits of the material at the institution. All these things you need to disclose. But if anything is wrong there, then you can say that this is wrong. And K is traditional knowledge. Okay, according to section 3P, traditional knowledge are not patentable. So the invention, as far as claim in any claim of the complete specification, is anticipated having regard to the knowledge, oral or otherwise, available within any local or indigenous community in India or elsewhere. So this traditional knowledge could be from India or from China. Okay, so those are things. So if you read in the book, section 25, pre-grant oppositions, very long sentences are there. So what I did, that I have put in very small language: wrongful obtainment, presence of prior art, secret patent, evidence of public use, obviousness, not invention, not patentable, insufficient complete specification, failure to comply with section 8, convention application not filed within 12 months, wrongly mentioned geographical sources, and traditional knowledge. So these are the grounds for pre-grant opposition. Okay, and whenever you will definitely get some questions on this. If you get a question to write if you get a scenario like this, question says, a client has come to you and you are a patent agent, and they want to oppose a recently published patent application. As a patent agent, what would you suggest to him? Okay, what would you suggest to him? So this is a question that may be asked in the paper 2. Again, this question can be asked. So how you need to address? You need to start from this. So according to section 25A, so you don't need to write as it is, but based on the situation given in the question, you can start saying that. Okay, nice. So according to section 25A, anytime before the grant, we can file. So let us fill form 7A, and there is no fee for that. And then other things you can say that these are the criteria for the pre-grant oppositions. Then you need to write all this from A to K, 25 on A, B. And then don't reverse these numbers. Don't write B as secret patent and the C as evidence of priority. No, you need to write A, B, C, D as it is given here, not an invention. And please read the actual text in the Patent Act, and then you try to make your own notes. However, this notice here also, I have given some additional details. For example, this prior art. So it says the prior art, but it should not be as per section 29A. So if you read the B, if you read the B 1 and 2, in India or elsewhere, provided the grant is specified in sections of clause 2 shall not be available where such publication does not constitute anticipation of invention by virtue of subsection 2 or subsection 3 or subsection 29. So these are given here. So I just made a note out of here. So you no need to write this. You can just write section A, wrongful obtainment, presence of prior art, secret patent, or evidence of prior use, obviousness, not an invention or not patentable, insufficient complete specification, failure to comply section 8, convention application not filed in 12 months, wrongly mentioned geographical sources, traditional knowledge. So this way you can write. So please make your own notes. However, this video and this discussion is available for you to use. Okay. So in a very short. Okay. So was it helpful this way?
Yes, sir.
Yes,
Yeah.
sir.
Yes, Prem.
Okay. So let us move to the next section. So this is called section 25. Let me, what I can do, I can